Hi, I'm Emily Previti, and this is Folo PA, the Pennsylvania Capital Star's podcast focused on policy affecting Pennsylvanians, featuring audio journalism that emphasizes context, accountability, and community impact. Pennsylvania lawmakers are under court order to come up with legislation that addresses cases where people are imprisoned on life sentences without any chance of parole for second-degree murder. Already, there are hiccups. The legislature blew its deadline to do that, which was July 24th, nearly 1 month ago, as of this recording. And we still have a few weeks to go until lawmakers come back from summer recess for the next legislative session. Still, for more than 1,100 people serving life sentences in state correctional institutions for this crime, it might be the first real hope for freedom. My colleagues Ian Carble and Whitney Downard took a closer look at who they are and made time to talk more about their findings. Ian, Whitney, thank you for being here.
Thanks for having us.
Glad to be here.
So, second-degree murder. What constitutes that offense? Can you give some examples of scenarios where that might be the charge?
Really broad picture, second-degree murder is a charge brought when someone dies during the commission of a felony. Say you were committing an armed robbery and someone died during that. That is second-degree murder. And that can be true for the person who fired the weapon, who beat someone, and it can also be true of, an example that criminal justice advocates like to bring up a lot is the getaway driver. Even if that person was not exactly present for the death, had never intended one to happen, never had any reason to think that would happen. And so there's really varying degrees of culpability for people charged with this crime. It's a charge prosecutors like to bring sometimes in plea deals with people who they may think that otherwise they could convict of first-degree murder. But at least until recently, everyone charged with it has gotten the same mandatory sentence, which is life without parole. And it led the Pennsylvania Supreme Court to say, in some of these cases, that may violate the state constitution's ban on cruel punishments.
As far as this charge coming up in a plea deal for someone who's initially charged with first-degree murder, because we don't execute in Pennsylvania or haven't. So even if you get the death penalty, it's essentially life without parole.
It was 1999 was the last one?
Right.
Thinking of it from a prosecutor's point of view, to bring a first-degree murder charge, you have to have the person who did the action that caused the murder and premeditation. And second-degree murder allows you to prosecute people and bring a very serious sentence against people who were involved in that and really took actions that led to that, even if that charge wouldn't stand. And there's some rare cases where first-degree charge will leave you with a lesser sentence than second-degree murder. Not first-degree murder. First-degree murder sentence is mandatory life. What I meant was things like voluntary manslaughter is the example that comes up a lot. And that's killing someone without premeditation. And that is a charge that does not have a mandatory life sentence. That is sort of similar-ish to second-degree murder and is one where, honestly, a prosecutor would probably have some, in certain cases, like, which one of these charges do I want to bring?
So in March, for the listeners who may need a refresh, the state Supreme Court determined that life without parole sentences for this offense are unconstitutional because they were automatic/mandatory, and therefore judges were prevented from giving full consideration to someone's personal culpability, their role in the crime. And that ruling happened on the case of Derek Lee. So can we provide a quick, short summary of that case for the listeners?
Derek Lee, he's a man in his late 30s who has been imprisoned for around a decade now. He was an accomplice in an armed home robbery in Allegheny County. When he was in another room, his accomplice shot the victim, Leonard Butler, and he was sentenced to life without parole for second-degree murder. Derek Lee was. So he found representation with the Abolitionist Law Center, which is a criminal justice advocacy-focused nonprofit law firm, and they petitioned the state Supreme Court to review his case and the legality of mandatory life sentences for second-degree murder. And that is what led to that ruling. That is what led to all of this changing.
But he's still incarcerated.
Yes, he has not had resentencing yet. The ruling basically found mandatory life sentences without parole for all second-degree murder cases. That violates the Constitution's ban on cruel punishments. You still can give life sentences in some cases when considering the totality of evidence or the circumstances. That's what Derek Lee's case brought out. And so basically he's going to have to go back to court and say, now I want to be resentenced. And that's really going to be up to a judge what happens to him next. I mean, I think he could still wind up with a life sentence. It's really just the mandatory nature of it is what the court found.
There are certainly prosecutors who I've talked to who have said that if you were present in a home with a weapon, then you should know that murder could happen and you should just be held equally complicit, equally responsible for that murder. So I do think it is very likely that Derek Lee and others in this group could still get that life sentence after their resentencing. I still think it's left to be determined. What a lot of the prosecutors are worried about is there's no structure for the sentences now. Previously, the sentencing hearing would be more of a formality because you knew everybody was getting a mandatory life sentence if they got this charge. So it really could lead to many different results.
It's impossible to say. And to your point, it sounds like it's kind of the Wild West and complicated. So putting all of that aside, you decided to learn more about who these people are, because that we can start to get a sense of. And those are people who were already prosecuted, sentenced under the old rules when life sentences were automatic for second-degree murder convictions. And you decided to do some data analysis. How did you approach that? And what were some of your top-line findings?
One of the big reasons that Whitney and I really started talking about taking a look at the data is that, especially in an election year, with this deadline from the Supreme Court, this issue became really political. You hear from sort of the criminal justice advocacy side about people like getaway drivers, people who weren't even in the room when a death happened. And there were a lot of comments made, mostly by Republicans, not exclusively, saying things like Democrats are introducing bills to let people out of jail who committed second-degree murder. They're going to release murderers into our streets. And it really did raise the question, like, okay, like, this is 1,100 people. Like, who are they? Can we get to the bottom at all of trying to figure out the breadth of experiences that these people have, the breadth of crimes that they committed, and the levels of culpability? And, you know, the social media posts taking particularly horrible cases and saying, these are the kinds of people who are serving time for second-degree murder. Whitney and I, we went to the Department of Corrections and we said, hey, just give us all the data you have on the people who are currently serving life sentences on felony murder charges. And they came back to us with a big spreadsheet. And obviously this data doesn't paint a great picture of who these people are. It's just really broad biographical data, you know, their age, their birthday, their race, what county they were charged in, how long they've been in DOC custody, things like that. The data was also a mess. Like, the way they classified people in terms of the crime they committed was not great. So we had to do a lot of filtering of data. I mean, there were first-degree murder charges in the spreadsheet they gave us. There were some people that were just classified as murder without listing a degree. And there's a lot of reasons for that, and some of that goes back to the way the definition of second-degree murder has changed over time, and I think just record-keeping changes. But we narrowed it down to around 1,100 people who we were very confident fit this criteria. And a few things that immediately stuck out to us. First, it's a pretty old population. More than half of them were over 50, nearly 10% were over 70, and a majority, over 50%, had been in DOC custody for more than 25 years. And there's a lot that's interesting about that. First, it raises questions about how this charge is used. Was it brought more in the past? And if so, why? And secondly, it raises questions about the effectiveness and cost of locking people up. Experts I spoke to, especially on the advocacy side, brought up this phenomenon called aging out of crime. And that's something that's been really widely studied. And studies repeatedly show that the older people get, the less likely they are to be involved in criminal activity. That has to do with social pressures, brain development, and honestly, just human nature.
That's violent crime, too. Even people who have been convicted of violent crimes age out of.
And so not only as people get older, and especially around the time when they reach their mid-20s, which is notably the time when the human brain really reaches its sort of adult form, people's likelihood of committing crime starts to plummet, and the same is also true of the likelihood of recidivism with ex-cons, especially those who commit violent crimes. That starts to go down. And another factor there is that it becomes much more expensive to lock people up as they age. That's primarily driven by health issues that just come with getting older.
Also, incarceration ages you more quickly. So someone is considered a geriatric prisoner at the age of 50.
Yeah, and on top of just, is this still a public safety measure when people get older? Is this costing more than it's worth? I think people also just have complicated feelings about what it means to lock people up in their 50s, 60s, 70s, etc., for crimes they committed when they're young. And another thing that stood out, almost everyone is male. The other thing that was just sort of like immediately noticeable looking at it is just the race of who is getting charged. Around 70% of the people serving these life sentences are Black. That's compared to roughly 12% of Pennsylvania's population that's Black. One thing that is notable is that the data that we have really is not great when it comes to breakdown of race. I think people were just classified as either Black or white.
Yes, there are no Latino designations, for example, or multiracial.
A huge number of people, I think it's around 550, give or take, were convicted in Philadelphia. And Whitney can talk a little more about what that means.
It was crazy when I started looking at the numbers. Philadelphia stood out for having almost doubled, sometimes tripled the rate of cases compared to other counties. And I did see that Philadelphia has historically approached this charge much differently from the rest of the state. The rest of the state has disproportionately used this type of sentencing in plea deals. So it's somebody who commits a first-degree crime, but they had them plead down to second degree because it resolves the case more quickly, spares the family a potentially traumatizing trial. Whereas in Philadelphia, more of these cases came from jury trials. But I couldn't really determine if it was related to any one administration or anything like that. And there's other data limitations. So the data definitely wasn't the best, but it was the best that we could get.
Yeah, I mean, sometimes what you're working with is what you're working with. I've experienced that trying to make sense of what we have from immigration and customs enforcement. And a lot of different organizations have worked on that and tried to make it easier for journalists, but it still is, there are some major limitations. Was there anything else in terms of limitations that popped up, or anything in talking to other organizations who were looking at it that,
I would say one limitation that I'm just remembering now, just to sort of have it out there, we could not see exactly how much time everyone had served. We could see how much time it had been since they were put in Department of Corrections custody. So that excludes any time they would have spent in a local jail awaiting a trial and sentencing, which can be like 2 years.
Yeah, and also there was no underlying charge data. So if we wanted to know, for example, if somebody was convicted of second-degree murder and another sentence, we would have had to look them up, each one up individually.
Which is,
And so we have no idea either if they were serving consecutive sentences for other charges and the clock for felony murder started later or earlier.
Did any of the advocacy organizations who you spoke with indicated that they were going to work on a custom data set as part of what they anticipate is going to be them working on these cases at some point?
So I don't remember anyone saying, hey, we're doing that. I mean, there was definitely people who made off-the-cuff remarks like, we'd love to do that. But there are people who have done this. One thing that's really interesting to me is both Governor Josh Shapiro and Attorney General Dave Sunday, Shapiro's Democrat, Sunday's a Republican, but Josh Shapiro wrote an amicus brief in this case saying you should find mandatory life sentences in second-degree murder unconstitutional. Dave Sunday wrote a brief in this case too, and his was like, hey, uphold this, right?
Yeah, so there's a number floating around. A couple of Republican prosecutors mentioned it to me, and I have not been able to chase it down. But essentially, there's a claim that somebody did an analysis of 500 felony murder cases and only identified one getaway driver. And so you'll see a lot of Republican prosecutors who were in favor of maintaining some sort of lengthy sentence saying this getaway driver is a myth. But from what I understand, that was not a complete analysis anyway. So I have not been able to get my hands on that data. If you have it, please send it my way. I have asked several people who thought they knew where it came from to share that, because I would love to see how they came to that conclusion, and if they didn't include all of the felony murder cases, why they only included a certain number. And that's the number I've seen Sunday citing as well.
Right. And I was going to bring up that both Josh Shapiro in his amicus brief and Dave Sunday in his amicus brief brought up an internal review the DOC did looking at the culpability of people convicted of second-degree murder. And Shapiro described it as it found only half of people they could really attribute the death that underlined that charge to the person who is serving that life sentence for felony murder. When it comes to the other half of people, about half of those people were not directly culpable, meaning they weren't the person that used the weapon or beat the person, hit them with a car, whatever it is. And then with another half of that half, they were unable to determine it. So that is something that exists. Our records request is pending. And another thing was that there was a group called Pulse. I am forgetting what that stands for.
That is the Philadelphia Lawyers for Social Equity. They did an analysis in 2021. And that is where we got the arson and kidnapping and sexual assault percentages from. I think 76% of these cases are an armed robbery of some sorts. And only 5%, 2% are arson, kidnapping, or sexual assault. And in Philadelphia, those cases are even smaller percentage of the types of cases that actually get convicted for second-degree murder.
In terms of multimedia, it hit a lot of marks. And the photo illustration, Whitney, you pulled that together. So can you just talk about how you created that?
Yeah, and I do have to shout out two of our former interns, Emily Skolnick and Ethan Young, for both really helping with more consulting. I'd show them examples and they'd say, oh, actually, why don't you try this? I can't remember which one of them actually suggested making the shape of the words in the middle, like the note paper, to look like the state of Pennsylvania. But since this is a audio format, it's a bunch of men who are lined up behind, and I did use all of their mug shots, which Ian and I discussed a lot about the humanity of that and trying to make sure that we emphasize these are individuals. But then there's an outline of the state in front of it that says second-degree murder in the Keystone State. And picking these photos, which all come from the Department of Corrections, was actually such a labor, because I didn't want to just include awful cases, and I didn't want to just include cases that arguably could be those quote-unquote getaway drivers or something like that. So I actually tried to include a variety of cases, and I'd find a case that I think would qualify, and then actually find out that they are being used by the Pennsylvania Innocence Project as a potential wrongful conviction. And so I did have to be very careful, but I wanted to make sure to convey that there is not a lot of variety in the terms of race and gender here. And I sent a dozen versions of trying to decide how big to fake the photos, how should I crop the photos, because I wanted to show what some of these men look like, but not necessarily focus on them.
You were really thoughtful in how you went about this and tried to make it representative. I think it's important for our audience to know that. And as we usually do, we'll have the link to the story, the full package in our show notes.
I think something Whitney touched on there, and first of all, she did an amazing job. That photo illustration was really her work and her idea. I just sort of saw multiple versions and went, I kind of like that one. But one discussion that we did really have together a bit is the ethics of including mugshots. And that is something that's been talked about in newsrooms a lot. And I think what really sold us is, if you look at it, it's every single mugshot we use is incredibly small. And it's very hard to focus on individual details in people.
You would have to really zoom in and look at each one and kind of know who you were looking for.
There's hundreds of pictures in this one image. And so that was really something that we did talk about that. And there were versions of this where sometimes the mugshots were larger. And that is in large part why we landed on the way it looks now.
And so any response or feedback so far?
Ian and I were really just trying to explore, hey, we're seeing all of these posts and public comments about who these people are that are locked away for this charge. What are the actual numbers? What do we actually know for a fact and not just as an anecdote? And people have some very strong feelings about this. I don't want to discount any victims and families. Those are very real wounds. That's trauma that you are going to be still healing from. But I've only gotten a handful of responses, much along the same lines, of people who had these preconceived takeaways and didn't come to the story to learn. They thought, no, we should lock them up and throw away the key.
Yes. You liberal commie, why are you advocating to let killers out of jail?
Got it. So they read the story.
Yes.
Whitney, you did a follow-up and talked to Philadelphia District Attorney Larry Krasner. We'll include that link in the show notes as well. And you noted that other DAs around the state seem to be ganging up on Krasner, who is, as our audience might be familiar with, a defense attorney turned progressive prosecutor, now in his third term. And for some of us who've lived in Philly for a while, outside of the city to the other side of the state and beyond, he's well known, and this tends to be the thing that happens with him sometimes. You've been here for several months at this point, so you're still pretty new. And what about that dynamic intrigued you initially or surprised you as you learned more about it?
What I think surprised me was learning that the Association for District Attorneys actually only has 66 members because Krasner is not a member of it. So I think that it's interesting to find that you really do have kind of 66 district attorneys grouped over here and then one district attorney pursuing something different over here. And when the GOP had 2 meetings about felony murder and crime earlier this month, and they both featured prosecutors who kind of were talking about how they were afraid or how they were warning about chaos. And then you have Krasner, who is handling half of these cases, unlike all of these other counties, which are handling less than 100, less than a dozen cases in most instances. And Krasner just said, yeah, we've done this before with juvenile lifers. We're going to kind of take the same tact where we look at who should be resentenced, prioritize, and then just go down the list. I talked to the district attorney in Adams County. He shared all 7 cases that Adams County has dealt with, which were all very pretty horrific crimes. And all of them were plea deals. With Krasner, 85% were from trials. So they're going to be doing this completely differently. That was one of the frustrations with how this issue has been painted. It's lacking that nuance. I think that was one of the problems that the Supreme Court identified, is that there's just no room for individual circumstances with a mandatory life sentence. And haven't noted yet that Pennsylvania really stands out for how long our sentences are for this. In both West Virginia and New York, so red and blue states, the minimum sentence for a second-degree murder charge is 15 years.
Right. And I did, in prepping for a conversation, check. Mm-hmm. And now there are only 4 states left with a mandatory minimum of life without parole for second-degree murder. And they are North Carolina, Louisiana, Mississippi, and Iowa. And then I did a little more research, and I didn't go super in-depth, but this was not some kind of trend decades ago. It was not a big group to begin with, so yeah. Ian, You touched on a prior story you wrote around the time the deadline passed for the legislator to act, which they did not, on developing a framework resentencing people. And you explain in that story that there's a likely outcome that's expected by people who are experts in this and sort of insiders.
To start there, retroactivity is the question of, so what happens to all the people who were already charged with this, are already serving life sentences? Because there's sort of two pieces of any legislation that could be passed. There's what do we make the mandatory minimum or the sentencing guidelines in the future? And then there is the question of 1,100 people who are serving life sentences that the Supreme Court found unconstitutional, at least unconstitutional for them to be mandatory. How do we address that? And one reason that the Supreme Court gave months to act on this is that can be a really messy process without guidelines. Basically, all of the bills that were introduced and fought over would have done was say, okay, after X number of years, person who is serving that life sentence for second-degree murder, you can go to the parole board and have your case reviewed, and they can decide what happens from there. And that's a process that is a lot cheaper and a lot easier for the people going through it than the alternative, which is without legislative action allowing people to go to the parole board, the most likely outcome is that a bunch of people who are serving these life sentences are going to file petitions to courts saying, excuse me, you found Derek Lee's sentence unconstitutional. I'm serving a mandatory life sentence for second-degree murder. I think this is unconstitutional too. And if the court agrees with that, that would basically kick off a much longer process than going through, you have to have a defense lawyer, and that can cost a lot. I think there's estimates of it costing, I'm forgetting how many millions of dollars.
I think it was 30 million, the mid-30s was the range that I saw in the stories that you've done.
Thank you, that is correct. So going before a parole board, much cheaper, much easier. It can also take many, many years for just a single case to move. We know that because back in 2017, there was a case that found mandatory life sentences for juveniles in Pennsylvania unconstitutional. And we had around 500 people who were given life sentences as juveniles who had to go through resentencing through the courts individually. That was 9 years ago, and there are still a small handful of people who have not had their resentencing yet. 1,100 people is more than double that number. So you can expect that to take a really long time.
And along those lines, we've been talking about the legislature and what to expect, what might inform it. So I guess the question is, now what?
There's been, I would say, like 3, maybe 2.5 serious proposals here. The first major proposal that actually passed a full chamber was sort of a Republican-backed bill that passed the Republican majority sentence. It did have some Democratic support, and it would have imposed a 35-year minimum sentence in almost all cases of second-degree murder. There was a very strict list of criteria where people could have their sentence reduced to between 10 and 40 years. Most people I talked to said that would be such a narrow number of people. You had to have not had a weapon, not caused somebody harm, any bodily injury. You had to not be the only participant in the underlying felony, not intended to cause harm, etc. Even Derek Lee would not have made that criteria. But, so there's a 35-year minimum sentence, and it would have allowed anyone who had served at least 35 years of their life sentence already eligible for parole, or if somebody was 70 years or older and had served at least 20 years.
Is that the component, the age gating of it? Does everyone seem to be, is that present in all of these?
I shared a case with Ian that I think will demonstrate how that some people that's not enough. An inmate who was convicted of second-degree murder, serving a life sentence, was quadriplegic and had less than 1 year to live, and they still wouldn't let him out. The prosecuting attorneys said he did such an awful crime, he should stay in prison. So for some people, even though the public safety risk is close to zero, it's not enough, and they still want to pay millions of dollars to keep these people behind bars.
I would also note there is a bigger conversation that sort of got rolled into a lot of this about something called medical release. The Democrat counter proposal basically to the Republican proposal that basically it would allow people to seek parole after 30 years. That bill, though, included a provision that applied to not just second-degree murderers, but basically anyone in a Pennsylvania prison. And it would have created something called medical release, where somebody who, if you're critically ill, could go to the parole board and say, hey, I'm not a danger to anyone. I'm really sick. I'm dying. I just want to go out and be with my family. And that was seen as, by Republican critics, just way too lenient. They were pointing out that people who were convicted of first-degree murder, really horrendous sexual assault cases, could say, hey, I'm critically ill, and get out. Or at least that was the picture that was being painted by opponents. And that bill just stood no chance in the Senate. Being controlled by Republicans generally takes a much harder and stricter stance when it comes to things like sentencing.
One of the things that frustrated Republicans is that they felt like they probably could have gotten somewhere on the parole after a certain number of years, but the addition of the medical release was too much for them. And that is something that they've really been hammering on social media.
So that could be the sticking point. Right now, that's what it looks like. Okay.
They've really been saying that they think it's way too lenient, that you can get it for having an eating disorder or diabetes, even though you would still have to go through a process.
Couldn't you put something in the bill, and at a certain point in time you have to stop legislating discretion? But let's use the example of an eating disorder. That is a very broad spectrum. Couldn't you include language where the individual would have to be compromised in terms of their strength or their ability to function? And there's language like that in some of these this medical release legislation that's been proposed previously.
I think that was just something that could have been addressed separately and might have had a more fair conversation, but combined with the second-degree murder emotions, it's just kind of fireballed.
The bill itself, it said that the inmate had to be seriously ill. And I think that the concern that was brought up by people who oppose it is what does seriously ill mean.
Okay, so amendment time, right?
Right. I think the one place where there is hope to sort of move away from medical release in the felony murder legislation possibly coming up is if you do have, let's say, House Democrats, because it was their bill that included it, say, okay, we're going to remove that. We're going to save that for another conversation, the medical release part. 30 years or 35 years isn't wildly far apart. Whether some of the Democrats supported the 30-year resentencing or parole bill would have accepted that number without something like medical release, I just don't know the answer to that. But there's enough there, and I think there's a lot of lawmakers who want to figure this out, genuinely do, on both sides of the aisle, in both chambers, that I think it is possible that they could come back and, after their summer recess, actually address this. That said, it's also an election year, and there is a lot of hesitation around passing bills that could in any way pop up in an attack ad.
I think that they possibly could come back in September and do something on this, but there's also a ton of other issues out there that are still unresolved as well. So it's hard to say when exactly we might see some resolution on this.
Yeah, and I think you're going to start seeing people submitting those petitions to the court saying, hey, I want a new sentence here. And if the legislator acts while they're going through that, they can withdraw and go through the parole board if they're eligible now.
All right, so thank you guys both so much for being here. This was a really good conversation, and I know this is unresolved and very complicated, so we will be revisiting it for sure.
Between me and Ian, we probably have half a dozen other follow-ups that we'd love to tug on, so this will definitely be getting more coverage.
Thank you for listening to Folo PA, the Pennsylvania Capital Stars podcast focused on how policy affects Pennsylvanians, featuring audio journalism that emphasizes context, accountability, and community impact. You can find us wherever you get your podcasts. And if you like what you've heard, we'd love it if you'd recommend it to a friend. To stay updated on the latest episodes and other work by our team, you can subscribe to the Capital Star's newsletter, The Morning Guide, at pencapital-star.com, and we've included that link in the show notes. Our theme music is Dusk by Mr. Smith, courtesy of the Free Music Archive, licensed under an Attribution 4.0 international license. Folo PA is edited by the Capital Star's Editor-in-Chief Tim Lambert, and hosted and produced by me, Emily Previti. Thanks again for listening.